Hello everybody, my name is TJ Scott. I'm an estate planning attorney with the Law Office of Timothy J. Scott. I can be found online at tjslawoffice.com. And today I want to talk about choosing an executor, also called a personal representative. And really, I'm going to be speaking about this more broadly. I'm going to be talking about choosing a fiduciary to administer your estate or to administer your trust because they're similar processes. I'll talk about that a little bit in a minute. An executor or personal representative is the person who administers your estate after you're gone. And for a will-based plan, that's often through the process, the court process called probate. For a trust-based plan, it's trust administration, and often that person then is called a trustee, not an executor. But they are a fiduciary with a similar role to an executor. So there's lots of overlap between the responsibilities of an executor and a trustee. Essentially, it boils down to this. The person needs to collect your assets, inventory your assets, pay any creditors, file taxes, and finally distribute assets out to the beneficiaries that you have listed. If you have them listed in a will, those beneficiaries are called devisees. If you haven't listed anyone, those people are called heirs, and they're determined by state law. If you have them listed in a trust, they're called beneficiaries. So things to consider when deciding on an executor or a personal representative or a trustee. Number one, is this person organized? And we used to say, can this person balance their checkbook? But honestly, how many of us are balancing checkbooks anymore? Administering an estate, you have to have somebody who can keep things organized. One of the important jobs that they have is inventorying your assets, and that means keeping a lot of paperwork and assets straight as they're working through the administration. They might also be called on to invest the assets and to collect things like dividends and interest along the way. Finally, they need to keep the creditors straight and make sure that bills are paid on time. And that's why it's so important that the person that you choose for your executor or for your trustee is an organized person. Another thing to consider, point two, is does this person stand to inherit? If somebody is going to both inherit and be the administrator of the estate, sometimes there's nothing wrong with that, and it can actually be less expensive for your estate to choose somebody who is going to inherit, because they'll choose not to be paid then, that they'll choose just to inherit the money instead of being paid for their work administering the estate. However, it can be difficult sometimes to balance the roles and responsibilities of a beneficiary with those roles and responsibilities of a fiduciary. So you just want to make sure that it's somebody who is going to uphold the duty of loyalty that they have and work in the best interest of the estate. Relationship dynamics are really important to consider here too. You want to ensure that this is someone who's going to be working in the best interests of the estate, and if there are other beneficiaries or other devisees or heirs who stand to receive, you want to make sure that those other beneficiaries understand that this person is working in the best interests of the estate, and ensure that hopefully it's someone that those beneficiaries trust to work in the best interests of the estate. Which brings me to point three, do I trust this person? Administering an estate, it's very important that it be a person, that you choose a person that you trust. That person is going to be carrying out your wishes. And this is especially important when you are choosing a trustee for trust administration, because often for a trust, there is little or no court oversight for that trust agreement. And instead, the trustee is making decisions on their own. It's true that the beneficiaries can bring that trust to court, but that creates a much more expensive process than what should be a pretty simple and a pretty private process in trust administration. For a personal representative or for an executor, there's already going to be some oversight from the court, but still you want to make sure that it's a person that you trust who is going to carry out your wishes in the manner and in the spirit that you want them to carry out those wishes. And so it's important to have somebody that you trust. Number four, does this person have the time and the energy to help administer an estate? Administering an estate takes a lot of time and energy, and it can be really difficult for a spouse or a sibling who's older and maybe grieving your loss at the time that they're supposed to be working through this process. However, sometimes that is the best person, even if they are going through a lot and working through a lot, because they are the most interested in the outcome, especially if they're receiving from your estate. One thing to consider here, there's a saying that if you need to get something done, give it to the person who looks busiest. And there's a truism there that oftentimes the person who looks busiest is going to find the shortcuts and get things done. That's often why they're so busy, is because they know how to get things done and they know how to take care of things. So don't necessarily give it to somebody who has all the free time in the world, because there might be a reason that they have all the free time in the world, and they may not be the best choice as an executor. Number 5, you need to make sure that your executor or personal representative is going to be eligible. Each state has different eligibility rules, but there are some kind of over guiding factors or some elements that are shared among many states. For one, the person has to be above the age of 18. I don't know any states that allow people who are under the age of 18 to be an executor for an estate. It is important that the person be of good character, and some states have tests to make sure that people are of good character, including not permitting that person to be an executor or personal representative if they've been convicted of a felony or fraud. It often helps to have an executor or personal representative who is located in your state. It means that they can travel to the banks that you use more easily. They can do things like collecting personal property and vehicles, motor vehicles, that kind of thing, more easily if they are in your state. There may also be more favorable rules that apply to them depending on the probate court that you're working through, again, assuming that this is a probate situation. You also want to make sure that it's somebody who has somewhat good credit. And this is especially true if it's somebody who lives out of state and is administering your estate, because that person may have to qualify for bond. And bond is like an insurance premium that makes sure that the estate isn't dissipated or isn't spent or doesn't go away in a way that it wasn't supposed to, but make sure that everything is taken care of the way that it is supposed to. But that bond is expensive, and not everybody qualifies to be able to get that bond. So it's important to have somebody who has a relatively good credit record. Oftentimes when we think of executor, personal representative, or trustee, we're thinking of family members. Thinking of our kids, we're thinking of our siblings, we're thinking of our parents, we're thinking of our nieces or nephews, somebody else, somebody in the family who can take care of this for me. But there are alternatives out there. One alternative is to find a friend, and it's important to note here that an executor, personal representative, trustee is often a paid position, that they can receive a reasonable compensation. So you don't have to feel like you are imposing on your friend. You can feel like you are paying them a reasonable wage for the work that you're asking them to do. And then you should feel comfortable asking them to take on that work. But it is important to ask before you just name them in that position. Another alternative is asking a professional fiduciary to take over the responsibility. Professional fiduciaries charge an hourly rate. The hourly rate depends on the professional fiduciary that you're hiring, but I've heard anywhere between $100 an hour and something like $300 an hour, depending on, again, who it is that you're hiring to carry out your wishes. And that may sound really expensive, but I can promise you a professional fiduciary is much cheaper than the next option, which is hiring a corporate fiduciary or a bank to administer your estate for you. Corporate fiduciary or a bank will often charge a percentage of the estate, something like 1 to 2%, or some kind of high flat rate fee in order to administer your estate. And it can be very expensive. You can imagine what 1 to 2% of an entire estate would look like. 1 to 2% of $1 million estate, for example, is $10,000 and would be, or $10,000 to $20,000, and would be more expensive than what a professional fiduciary would likely cost. Another thing to consider, bring this to your estate planning attorney in order to have them talk you through the process and talk you through the different roles and responsibilities of an executor, of a personal representative, of a trustee, and talk to you about the people in your family, the people in your friend group, and talk about the different options that you have and who might be a good person to take on that role. Again, my name is TJ Scott, and I'm with the Law Office of Timothy J. Scott. I can be found online at tjslawoffice.com.